22. Preferential right to acquire property in certain cases. What the section 22 says. After the commencement of this act, this section 22 is applicable only after the commencement of this act. The interest in any immovable property of an interstate or interest in any business carried on by him or her, slowly or in conjunction with others, devolve upon two or more heads specified in class 1 of the schedule, and any one of such heads proposes to transfer his or her interest in the property or business, then the other head shall have a preferential right to acquire the interest proposed to be transferred. So this is the verbatim of the section 22. Now we will see what the section 22 says in the simple words. This section 22 is applicable only to the head or heads of the class 1 heads. Class 2 heads, agnates and cognates, this section is not applicable. Suppose the 4 heads, because in the class 1 there are 16 heads, out of the 16, suppose if the 4 wants to carry out the business, they started a business, then this section 22 is applicable. Suppose if any of the head want to transfer his business. Suppose if the class 2 heads, 4 heads have started a business, then this section 22 is not applicable. Similarly, agnates, if they start the business, this section 22 is not applicable, and similarly the cognates. So this section 22 is specifically applicable only to the head or heads in the class 1 heads. This is the first condition. Second, to any movable property or to the business. To any immovable property, immovable, not movable, immovable property or business. And third says, all these class 1 heads, for example, you take A, B, C, D, all are class 1 heads. They started a business. They started a business. One of the head, for example, you take A. A proposed to transfer his interest. He want to transfer his interest. Then B, C, D are the preferential heads. First offer is to be given to the B, C, D. First the A has to give offer to the B, C, D. Now the B wants to take his interest. A want to transfer his business, and now the B wants to take his interest. So both A and B together will fix some price. The B will pay the price and A will transfer the interest to the B. Suppose if they could not come to a conclusion about the consideration or the price, the A quotes something and B says something, they could not come to an understanding, then that will be determined by the court. The court will fix the price. So to fix the price by the court, an application is to be made to the court. An application is made to the court. After paying the court by making an application, the court will fix the price. Suppose if they come to a common agreement and B proposes some price, and if A agrees, then the court is not necessary, involvement is not necessary. When they could not come to an agreement about the price, then the court will determine the price by making an application. So if the person, the court now fixes, they put an application, the court fixes the price. But the price fixed by the court is not willing by the B. The B is not agreeing the price fixed by the court. Then B is liable to pay all costs of the application. The B is liable to pay all costs, whatever the expenses that have been incurred, to be paid by the B. Suppose in case of plurality of the claimant, I said that A, B, C, D, all the class 1 heads have started a business. Now A want to transfer his interest. All B, C, D wants to take the interest. If all the B, C, D wants to take the interest, to whom the A has to give? The head who offers the highest price shall be preferred. The heir who offered the highest price shall be preferred, and that person will take the interest of A. Suppose there are all these B, C, D are the preferential heirs. First, this offer has to be given to him. Offer is to be given to any of these heirs. If the A, without informing to the B, C, D, transfer his interest to some third party, that is X or Y, what is B, C, D can do? Because they are the preferential heirs, first offer is to be made to the B, C, D. But here A did not do so. He transferred his interest to some X or Y third party. What is the remedy that is available to the B, C, D? They have to file a regular suit in the competent civil court and not by way of application. They have to file a suit before the competent court. What is a court? Here the court means the court within the limits of whose jurisdiction the immovable property is situated, or the business is carried on. Where the immovable property is or where the business is carried out within the local jurisdiction, that court will have a jurisdiction to deal with this matter. Or sometimes the state government by notification in the official gazette specify the court. That court will also deals with such matters, either where the immovable property is situated or where the business is carried. Within these limits, the court will have a jurisdiction. Or sometimes the state government by notification in the official gazette specify the court, and that court will have the power to deal with these matters. And in Babu Ram versus Sankot Singh case, here the Supreme Court held that the immovable property includes the agricultural land. That is, suppose if A, B, C, there are 4 acres distributed equally to the A, B, C, D, all are A, B, C, D are the class 1 heirs, and now A want to transfer his 1 acre, or he want to sell his 1 acre. First he has to offer to the B, C, D. Then the rest of the procedure is to be followed. So it includes even the agricultural land also. But the right of preemption cannot be claimed once the partition is made. So this was held in Krishnapada Rai versus Parimala Chandra Saha by the Guwahati High Court. Once the partition has been made, this right of preemption cannot be claimed. This section says that the rest of the heirs are the preferential heirs. They have the preferential right, but they do not have the absolute right. No absolute right. It is only the preferential right. But the section does not stipulate that before one proposes to the property, he should intimate his intention. How he has to intimate his intention? Calling upon them to indicate their willingness. That doesn't mentioned anywhere in the section. But the Orissa High Court clearly held that if any of the heir wants to transfer his interest, he must propose or notify his intention to the other co-heirs. Suppose if he, without giving the notice to the co-heirs, if he transfer his interest to some third party, the whole transaction is ineffective. In the absence of the notice given to the co-heirs, the Orissa High Court held that even though the transaction is completed, the whole transaction is ineffective. This is the preferential right to acquire property in certain cases. So this is applicable only to the class 1 heirs and immovable property and to the business. And section 23 deals with the right of dwelling house. What is a dwelling house? There was no specific definition of the expression of dwelling house. It is not explained or described anywhere in the Hindu Succession Act. No definition, no explanation, no description. But in Commissioner of Income Tax versus K.S. Ratnaswamy, the Supreme Court quoted saying that the expression dwelling house means residence, abode or home. In other words, dwelling house is a place where an individual is supposed to live and sleep. So, it is a place where an individual is supposed to live and sleep. The definition given by the Supreme Court in Commission of Income Tax versus case Ratnaswamy, but Hindu Succession Act has not given any definition to that dwelling house. And now, what are the rights of the dwelling house? Here you have to divide into two sections. One is before the Amendment Act 2005 and after the Amendment of 2005. Before 2005, we'll see. When Hindu person dies intestate without writing a will, and the property includes the dwelling house, the intestate had a property which includes the dwelling house also. That house is wholly occupied by the members of the family. The house is occupied by the members of the family, both male and female, whoever it may be. Then the female has no right to claim a partition in that dwelling house. The female has no right to claim a partition, has no right to ask his share in the dwelling house until the male heirs decides. First the male heirs has to decide that to file a suit for partition for their respective shares. If the males are decided that they want to file a partition suit so that they want to divide the dwelling house, then the female will also have the right. In the rest of the cases where the members are residing in that particular dwelling house, the female has no right to ask for partition. Thus section 23, this is section 23, makes the female disentitled, so she cannot claim for partition or share in the dwelling house. But if the female is a daughter, she is entitled to the right of residence, not claim of partition, not partition. If the female is a daughter, she is entitled to the right of residence in the dwelling house under four conditions. Suppose if the daughter is unmarried, she has a right of residence. If she is deserted by her husband, she can reside in the dwelling house. Or separated from the husband, she can reside in the dwelling house. Or widow. Unmarried, deserted by or separated from, and widow. Then the daughter has the right of residence and not the claim of partition. But this section 23 was omitted by Amendment Act of 2005. So the Amendment Act has given the full rights to the daughter. She is also to be treated as a co-partner. Under the Amendment Act, the daughter is also a co-partner. By birth, she is entitled to take the share in the ancestral property, and almost all whatever the liabilities and rights the son had, the daughter will also have. So automatically she will also have the right to claim a partition in the dwelling house. After the amendment, the female has a right to claim a partition in the dwelling house. Even the male has not filed a suit for partition. Even if they are silent, even if the male heirs are silent, they have not filed a suit, they have not expressed that they are going to divide their respective shares in the dwelling house, the female has a right to claim for partition in the dwelling house. Thus, the female has both residence as well as claim partition after the Amendment Act of 2005. And the last section 29, failure or absence of heirs. This section 29 of the Act provides that if an person dies having the property but there are no qualified heirs. Why I am saying the qualified heir means the heirs must have a qualification. The qualified heir, there are no qualified heirs, then the property will be taken by the government. Suppose if the intestate had any obligations or debts or liabilities, the government first clear all of them and the property will be taken by the government. So these are the general rules or the provisions applicable to the Hindu Succession Act from section 18 to 23 and 29. These are the sections.